All right, John. So we're going to be hitting on the topic of what happened to state rights.
State rights.
State rights. Now, first of all, a lot of people say, so you see, you hear states' rights all the time. So you've corrected me on that. So it's not states' rights, right?
Right. Yeah. Just to go to a little historical context, is originally they were called state rights because it was the rights of the individual state versus states' rights, the rights of the states as a whole or as a body.
Okay.
So if you go in the Civil War period and before, you'll never see them putting an S on the end of states because they're talking about, hey, I'm in North Carolina. We're talking about our state rights.
Okay.
It's our state rights here in North Carolina. It's South Carolina's state rights. And so let's just get a little bit of, so our topic is what happened to state rights.
Well, let me first of all, let me clarify, because I mean there are people that may not be that may have hated history in school as much as I did. Let me ask you, what are state rights? I guess my opinion of what state rights are would be the state has rights within itself outside of the dictates, or as we would see them today, the dictates of the federal government. Right? Is that
pretty much
close?
Yeah, that pretty much nails it on the head. You have to remember that when we created this union, not a nation, a union of several, the United States, the states were united, not a nation called the United States, that we created a limited federal government. Mm-hmm. Okay, so a limit, and the states retain their sovereignty. Mm-hmm. And the states retaining their sovereignty, that concept is mentioned in the Articles of Confederation. It's James Madison mentions them in the Federalist Papers, that each state retains its sovereignty in drafting this, or not drafting, but becoming part of the Constitution of the United States of America.
Each state is a sovereign country.
Is a sovereign country. They're nations, and so they didn't want this overbearing federal government, which is what we have today. Where are our state rights? How come we can't act autonomously from the federal government? Is a general concept. Mm-hmm. And so we've got the 10th Amendment. I think the 10th Amendment was very clear on this. Even though the Constitution enumerated the certain authorities that the federal government had, they were afraid that, well, they may start operating outside of it. So they started amending the Constitution, the Bill of Rights. So the 10th Amendment is commonly called the States' Rights, or the State Right Amendment. And it says this: the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Okay, so it's reserved to the states or to the people. Okay, so powers not delegated to the United States are reserved to the states. Federal government, you can't exercise it. Mm-hmm. We reserve it.
It's up to the states to decide where they stand on certain issues.
So some of the common exercises of this were, liquor by the drink that we see today. Each state could decide, I want liquor by the drink. We don't want liquor by the drink. We could be, we had gambling. Nevada used to be, they had a state right, they could have gambling. Other states said, well, we don't want gambling. And that's kind of how we see that we still have a little bit of what we consider state rights, but this is just how we decide to order our affairs. We can still have gambling if we so choose. But the issue is, what's changed is the federal government says you can't do it. No state can do it, whether it's a power in the Constitution or not. And these are the issues like abortion. Okay, so abortion, it used to be, if you had state rights, one state could say, we consider it illegal. And another state would say, well, we want to consider it legal. Okay, that would be the exercise of state rights. But the federal government has come in and says, no, you're required to have abortion. You cannot outlaw it. Okay, so
it's argued in one state, and then all of a sudden they can apply.
And this is because the United changing from state citizens to United States citizens, and we're going to get into that.
Okay.
But let's just start this conversation by, what is a state? Number one is, and I'm just giving some definitions out of law dictionaries and regular dictionaries. So the state is government. This word is used in various senses. In its most enlarged sense, it signifies a self-sufficient bodies of persons united together in one community for the defense of their rights and to do right and justice to foreigners. In this sense, the state means the whole people united into one body politic. And the state and the people of the state are equivalent expressions. And I think this is something that people really, really need to understand. When you say the state, you really mean the people of the state. Okay? The state government is the people's government. State laws are the people's laws. The people of the state and the state are the same thing.
So it's when somebody says, well, it's up to the state to decide.
That means it's up to the people to decide. But most people think it's up to the government to decide.
Yeah.
No, it's up to the people to decide. And our representatives are supposed to exercise the rights of the people, not the dictates of the federal government. Okay, and this is a big difference.
All right.
Again, as a noun, a state is a people permanently occupying a fixed territory bound together by common habits and custom into one body politic, exercising through the medium of an organized government, independent sovereignty and control over all persons and things within its boundaries, capable of making war and peace and of entering into international relations with other states. Okay, so a state is a body of people permanently occupying a fixed territory. So we got a body of people. Now the issue is a body of people, does that mean all people within its borders? And this is one of the confusing concepts, because one of the changes that happened with the Reconstruction Acts is, the state of North Carolina, which was recognized by the Crown of England in the Definitive Treaty of Paris, was the freemen of North Carolina that resisted the Crown. Was it, did the Crown recognize the state of North Carolina as being the Tories that were in North Carolina, the people that were loyal to the Crown? Well, no. Even though they lived on the soil here, they didn't have the political power. In other words, who has political power is the state, the body politic. You get to exercise your political power. Political power. Mm-hmm. Think of this as synonymous terms. Who can vote and who can hold office. That's your body politic.
The people that were there, the other people that were there, like you mentioned, the Tories, right? The
Tories, slaves. You go to women. Women really weren't a member of the body politic. Mm-hmm. Now, could they become a member of the body politic? Well, yes, but properly it had to go through the body politics that is there has to decide who it wants to enlarge its political rights to. Mm-hmm. And again, we do that with foreigners. We don't just say any foreigner can come over here and all of a sudden you can start voting and holding office. And the body politic has always been this group of people. Well, who is this defined group of people? The state in North Carolina were the freemen of North Carolina.
And that's a term as stated in the Constitution.
Yeah, the Constitution of North Carolina in its preamble says this is a Constitution and form of government for the freemen of North Carolina. And that was, the Constitution of 1776. Who was the state of North Carolina? Well, the state is the people. Who were the people? The freemen of North Carolina. So, state and people are synonymous. North Carolina was the freemen of North Carolina. And they had residual, sovereignty that they could exercise that wasn't granted to the federal government, to the Constitution. Okay? When did this change? Let's look at what Abraham Lincoln did in 1861. The southern states, some of the southern states started seceding from the Union. Okay? They used the method that was prescribed in the Constitution, Article 7. Article 7 says, because Article 7 is how do you secede from the Articles of Confederation? The Constitution is, how do we secede from the Articles of Confederation? In other words, how do we leave the Articles of Confederation lawfully? Well, Article 7 of the Constitution says that once 9 states, after having conventions of their people, vote to leave the Articles and adopt this form of government, then it becomes binding on those 9. So it says that once they have, conventions, then it becomes binding on them. Well, what is this an example of? This is an example of the states have a right to alter their form of government, right? They have a right to abandon a form of government, the Articles of Confederation, and go into a new form of government. Because as we know, when we went from the Articles to the Constitution, it wasn't as a body of 13. Each state had to vote individually to get over there. North Carolina and Rhode Island were not in the United States of America under the Constitution of the United States when it was inaugurated. We were not. There were only 11 states in it. So that shows you, we didn't go as a body. The states had a right to leave one, go to the other, without war being waged. Okay? And it's in the Constitution of the United States how to do it. You hold conventions. Well, Abraham Lincoln said, okay, South Carolina, you voted to secede. That's a crime of treason, okay, for which we can wage war. Well, cite the law. Okay, show us the law that says it's treason. Show me the statute. Show me the principle. Because leaving the Union, we just did it, going from the Articles to the Constitution. By holding conventions, South Carolina held a convention. Well, let's look at North Carolina. North Carolina voted to stay in the Union. Within a week before Abraham Lincoln was inaugurated. We're staying in the Union. We left when Lincoln sent a letter to the governor saying, we want you to provide troops to wage war on these states that have that are trying to leave the Union. North Carolina says, we can't wage war on free states. They have a right to alter their form of government. It's a principle of this country. So
I've seen I don't know if you're bringing that up yet, but I've seen the paperwork where you go over all of the different founding documents that mention the concept of secession.
Right.
In those documents.
And secession is the formal leaving of an organization. Can you formally leave lawfully and peacefully?
Yes.
And according to the principles of this country, we have a right to leave. You know, the Declaration of Independence. You know, people have a right to alter and abolish their forms of government. They got a right to do it. Well, who are the people? The people are the people of the states. Okay. Well, Abraham Lincoln saying, well, all that changed. That the United States is a nation of one people. It's not a union of states. So Lincoln says the governments, the state governments, have no right to leave the Union. The federal government can wage war on them. Well, so what happened after this? Well, Abraham Lincoln did that by what's called a Bill of Attainder. A Bill of Attainder is when you signify a certain class of people, you say they are guilty of a crime, and you punish them for that crime, or have the authority to punish them for that crime without a trial, without due process of law. That's what a Bill of Attainder is, grabbing a group of people. Well, he's saying these people in South Carolina, the freemen of South Carolina, and then later the freemen of North Carolina have committed this crime of treason. Well, they're saying, bring us up on charges. Let's settle this in court. And you'll know that this concept of whether secession was treason has never been adjudicated. It's never happened. And so
as
they say
told
that,
us.
Yeah, as they've told us. And so now you got the end of the war, and you've got the federal government still operating on this principle: the Southern states committed treason, you know, under this Bill of Attainder that Lincoln did. And so they say they go through Reconstruction. And what did Reconstruction do? And we talk a whole lot about this. You know, what Reconstruction was about was changing the United States from a union composed of sovereign, demi-sovereign states with their individual body politics, and changing it to a nation of one people. In other words, everyone's going to be a United States citizen, a citizen of Congress, to where Congress has exclusive power over us. Okay? So we go to the Reconstruction. What was the Reconstruction Acts about? It was about coercing the passage of the 14th Amendment, the United States citizenship status. The 14th Amendment, what Reconstruction did, it's the only, just openly coerced amendment. In other words, Congress said, we're going to annul the state of North Carolina, we're going to create a new state, you know, we're going to, that body politic doesn't have a right to exist. What's the body politic? That's the state. That state doesn't have a right to exist. Another Bill of Attainder. And we're going to create a new body politic, and they have to have a new constitution, and we're going to change who can vote in the states from state citizens to, you know, anyone born in the United States. Change the body politic.
It basically says a lot of that in its opening paragraph, really, in the opening paragraph of the Reconstruction Act.
It clearly says that. And they did that based upon the principle of conquest. They said, we're going to consider the states to be conquered territory, and we can govern them as we choose.
2 years after, a year after peace had been declared.
A year after peace was declared. The war was over in 65. The states were in the Union in 65. Peace was declared in 66. Then Congress annuls the states and says, we're annulling them based upon the principle of conquest. Okay. These were vetoed by Andrew Johnson. And in fact, in one of Andrew Johnson's vetoes of the Reconstruction Acts, he said this: another ground on which these Reconstruction Acts are attempted to be sustained is this, that these 10 states are conquered territory, that the constitutional relation in which they stood as states toward the federal government prior to the rebellion has given place to a new relation, that their territory is a conquered country and their citizens a conquered people, and that in this new relation Congress can govern them by military power. He says a title of conquest stands on clear ground. It's a new title acquired by war. It applies only to territory. So what you have here is you got the federal government saying, Congress saying, we have conquered the states. Who owns North Carolina now? Congress does. Who are they going to populate with a body politic in North Carolina? It's citizens that recognize Congress as supreme and sovereign,
United States citizens.
Which is United States citizens. And so now, what happened to states' rights? Well, number one, state citizenship's annulled. Okay? Now, this concept of, well, everyone in the states is now United States citizens who reside in the states. Well, who has authority over United States citizens?
Congress.
The federal government. They can pass exclusive legislation in all cases whatsoever. And to further go into this, I'm going to go into what James G. Blaine says. James G. Blaine was a radical Republican congressman during the Reconstruction. He gave a speech on the 14th Amendment because one of the misconceptions on the 14th Amendment was it was about giving blacks civil rights. That's what it was about. giving blacks civil rights. And I'm saying it's about nationalizing citizenship, changing from state citizenship to nationalizing us, which gets rid of states' rights. And he says this in a speech he gave in Skowhegan, Maine on August 29, 1866. He says, but we do intend that, that they shall be admitted to citizenship. He's talking about the freed blacks. And they shall have the protection of the laws, and they shall not, any more than the rebels shall, be deprived of life, liberty, or property without due process of law, and that they shall not be denied the equal protection of law. And in making this extension of citizenship, we are not confining the breadth and scope of our efforts to the Negro. It is for the white man as well. We intend to make citizenship national. And he goes on, he says, heretofore a man was made a citizen of the United States because he was a citizen of one of the states. Now we propose to reverse that and make him a citizen of any state where he chooses to reside by defining in advance his national citizenship. And our amendment declares that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. This amendment will prove a great beneficence to this generation and to all who shall succeed us in the rights of American citizenship. And we ask the people of the revolted states to consent to this condition as an antecedent step to their readmission to Congress with senators and representatives. In other words, you know, this is where they're saying that, and he's saying this before it's passed. This is 1866, before Reconstruction. He says, we're saying you need to accept total subjugation to Washington before you're going to be readmitted to Congress. And it's like, wait a second. Where does Congress get the authority to do that? He's being very clear. In 1866, when the amendment was proposed in June, this speech is given in August, it's just a couple months later, we see the intent right here, that it's about nationalizing citizenship and changing the citizenship from state citizenship to citizens of the United States. And he's saying it's a reversal of what we had, which I would say it's the overthrow of the foundation of this country. It's the overthrow of what the founders put into place. It's the overthrow of a union, the creation of a nation, which is not authorized.
I almost see this as a almost sort of not a preliminary step, but something that came before. You know, right now we're looking at the possibility of world government. A lot of people are scared about that, and it's basically just taking the lump sum of all and, you know, again, grouping them into one. But this is kind of the exact same thing that happened at that point. Absolutely. The states were individual countries. Now let's lump them all together into one. And what applies to you in this state applies to you pretty much the same. You know, it's doing away with that state sovereignty.
And that's what the UN, a lot of these UN treaties are about. You know, the UN Treaty of the Child, you know, spanking children and all this stuff, abusing child actually comes from the UN dictates. These aren't things that we just created on our own. You know, so we're getting a lot of that stuff going also. You know, I can actually do a talk on all that with the North Carolina said that we want to be we're resolved to attain one world government, and we ratified that in 1941. So that's been on the books going on for a good while also.
Wow.
But let's just go back to James G. Blaine. He wrote a book, 20 Years of Congress, 1861 to 1881. He's talking about the 14th Amendment. Again, what's our topic here? What happened to state rights? What happened to them? Because it's in the news. Everyone's saying we want our state rights back. You know, federal government's operating outside of its bounds. We're saying that through this legislation, the Reconstruction Acts, Congress got exclusive legislation over all people, over all states.
Okay.
And so James G. Blaine, in another one of his books published in 1884, he's writing about this period of time. He's writing about the 14th Amendment and these new state constitutions. And he says, all these constitutions, all were ordained in the spirit of liberty, you know, changing the citizenship from state citizens to national citizen, you know, where Congress has total authority over them. He says, all this was ordained in the spirit of liberty, all prohibited the existence of any form of slavery, and all heartily recognized the supreme sovereignty of the national government as having been indisputably established by the overthrow of the rebellion, which was undertaken to confirm the adverse theory of state rights. The adverse theory. So he's saying that the Reconstruction Acts, the purpose of it was to overthrow this theory, this adverse theory that he calls state rights. And he goes on in his writings, and he says, as the vicious theory of state rights had been constantly at enmity with the true spirit of nationality, the organic law of the Republic should be so amended that no standing room for the heresy would be left. Now let's just restate that. Number one, it's the vicious theory of state rights. Well, what's our topic?
What happened to state rights?
Well, it was a vicious theory according to Congress in the 1860s. Okay? So this vicious theory of state rights had been constantly at enmity with the true spirit of nationality. Well, were we a nation or were we a union?
We were a union.
We were a union. Well, of course it's going to be in conflict and have friction with nationality. That's not what our founders set up. So he said, to fix this, the organic law of the Republic should be so amended, that's the 14th Amendment, so that no standing room for the heresy. What's the heresy? State rights. So no standing room for the heresy of state rights would be left. So the object of the 14th Amendment was to nationalize citizenship and get rid of state rights. If you get rid of state citizenship, what's a state? The state's the people, the freemen of the states. If you get rid of all the 50, well now it'd be 50, back then it was 36 or 37. If you get rid of the freemen of the several states and now they're all one citizenship, well, do you have state rights? Well, yeah, you just have one state rights. The people and the government are the same. We're all United States citizens. It's all United States government. We're all one people.
The states are federal satellites.
Now the states are just federal satellites, and it starts making sense. Oh, well, we do have state rights. It's just that we're all one state.
States.
It's all the nation.
Rights.
It's the states' rights. It's as a collective.
Yeah.
Us all together. And so when we come all together and say we don't want abortion, then it affects everyone in here, because we're all one body of people. We don't have the individualness of state citizens.
So now you have people in these individual states. They're still states, called states. But now they're railing against every different issue because they don't have any choice anymore. Nobody has a choice, really.
Right.
Because we're all being, federal government's like, oh, well, you want one thing and you want another. They have to make the ultimate decision, and you end up with angry people all over the place. Well,
yeah, we have chaos right now because we're looking at the Constitution as being the fundamental law. Okay, that should be binding, a limited federal government. And we're looking, well, do we have a limited federal government? Well, no. Well, the states should be able to have state rights and do what we want in our state. We can pass an amendment against abortion. The federal government comes and says, no, you can't do that. Oh, well, we'll pass an amendment against and define marriage as between a man and a woman. Well, it hasn't been totally done yet, but that's going to go away, because if a citizen of the United States has a right to marry, if a man has a right to marry a man in one state, then under this principle, he's going to have that right in every state. The issue is it's just got to go before the court and get the ruling.
And of course, I'm sure I'm sure this is a whole other talk, but as far as where the federal government is erring, in other words, which side of the fence they're usually erring on is I don't know. It's to me and you, I guess it would be more on that liberal side of, or it's.
Well, there's two philosophies. Well, I think you can break it down simpler. There's two fundamental philosophies. You either have your laws and you recognize, and the issue is who's sovereign. Where does sovereignty reside? And when this nation was founded, we felt that sovereignty resided in God. God was the sovereign. You had to be a Christian in order to hold office. We can't violate God's laws. We believe God wrote the laws. Well, now we want to have liberty, and you can have liberty under God to do whatever you want. So what liberty is? The ability to do whatever you want without other people saying you can't.
And you're not talking about stoning children and things like that.
I'm not talking about stoning children.
Everybody always goes off the deep end.
Well, again, you got to put the general principles out, and then, that becomes another topic of, those can be addressed individually. But here we want to deal with kind of the big topic, and we get into individual stuff later. And the big topic is we can do whatever we want to under God. And now it's what we get to do whatever we want to regardless of God. Humanism. So are we a moral and religious people? Which, our founder said this Constitution, this form of government, this type of freedom can only be for a wholly moral and religious people. It can be for no other. Okay? Because you have to have, what's a state of people with common beliefs? You have to have a common belief. Well, we believe this. So now we know what our parameters are. Well, now we have the concept of, we get to have liberty regardless of God, outside of God. It's humanism. It's whatever I feel. And what I feel may be different from what you feel. And you should respect what I have. Well, this is humanism. This is secularism. And so now I get to do whatever I want, as long as I don't hurt somebody, which is a Wiccan philosophy. That's a philosophy that comes from Wicca.
Which we'll cover later.
Which we can cover later.
But just to tie it into this, now the federal government, as grouping us all together, they're erring on that humanistic side.
Absolutely. In fact, what you're going to see is the principles this nation were founded on are actually the opposite principles the government's operating on today. It was based on states, now it's, and a limited federal government, now it's an unlimited federal government, and states are virtually gone. It was originally God was a sovereign, now we want God out of here. We can't talk about God. God is to be, the Christian God is to be thrown out, because the Christian God is the God of the foundation. All these other gods are being welcomed. Mm-hmm. They're the ones being welcomed in. You got the Democratic National Convention. I don't know when this is going to be on YouTube or on the webinar, but it's happening in a couple weeks. And if you look at the Democratic National Convention here in Charlotte, they're going to have 2-hour Jumu'ah prayers for the Muslims, and they're celebrating this, the 2-hour prayers. The Christians are having a tough time even getting someone to speak there. They don't want Christians there. Mm-hmm. So we've got issues here. They got the gay rights going on. Well, is that opposed to, we had a gay right parade. Is that opposed to the foundations of this country? Yes. Well, they're saying, well, this is an exercise of liberty that our founders would celebrate. Well, no, it's not. This is an overthrow. This is liberty outside of God, because, that's not the beliefs we have. Yeah. But again, let's just keep going here. I just want to do a couple more things of what James Blaine said. Okay. Talking about the 14th Amendment. And he says, the first section of the amendment, this constitutional amendment, which includes these invaluable provisions, is in fact a new charter of liberty to the citizens of the United States, is the utter destruction of the pestilent heresy of state rights, which constantly menace the prosperity and even the existence of the Republic, and is the formal bestowment of nationality upon the wise federal system, which was the outgrowth of our successful revolution against Great Britain. Here's another section that says, its opening section settle all conflicts and contradictions on this question. In other words, where does your citizenship come from? Does it come from your state or the federal government? It says it settles all conflicts and contradictions on this question by a comprehensive declaration which defined national citizenship and gave to it precedence of the citizenship of a state. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. These pregnant words distinctly reverse the origin and character of American citizenship. Instead of a man being a citizen of the United States because he was a citizen of one of the states, he is now made a citizen of any state in which he might choose to reside because he was antecedently a citizen of the United States. The consequences that flowed from this radical change in the basis of citizenship were numerous and weighty. And so we see that, he's saying, that it reversed the origin and character. We would say that's bad phraseology. It overthrew the origin and the characteristics of government and the rights of citizens that we originally had. This is the overthrow of what was put into place. Abraham Lincoln starting it with the Bill of Attainder, Congress implementing it with another Bill of Attainder, putting national citizenship in, all under the guise of this was a moral cause to free the black man.
I think that makes it pretty clear what happened to state rights.
They're gone. They're gone. And let's to further beat this up, let me give you a couple Supreme Court rulings. What the Supreme Court has ruled on the 14th Amendment. This is Elk versus Wilkins, 1884 case. It says the persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words, which is subject to the jurisdiction thereof, is not merely subject in some respect or degree to the jurisdiction of the United States, which is Congress, but completely subject to their political jurisdiction and owing them direct and immediate allegiance. Okay? So we are, completely subject to their political jurisdiction. Not a limited federal, that doesn't sound like a limited government. There's no limitations there. You got Jones versus Timmer. It says the Privileges and Immunities Clause of the 14th Amendment protects very few rights, because it neither incorporates the Bill of Rights nor protects all rights of individual citizens. Instead, this provision protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. And again, you're seeing this openness about there's different rights for a federal citizen and a state citizen. And then I love this one. This is U.S. versus Valentine. It says the only absolute and unqualified right of a United States citizen is to residence within the territorial boundaries of the United States. And I think that just kind of sums it up right there.
Yeah, I've asked that question to people before just to see what responses I would get. Is that, how many rights, what are the rights of a U.S. citizen? And how many rights do they have? They have one right.
Right.
They can live here. That's about the only right that they have.
Right.
So you want to states' rights? There you go. There's your state. There's your right. That's
your right to live here, and it can be in a cage with 10 by 12, and they are not violating your rights at all.
And I'd also like to reference. I don't think
Federalist
you have it
39.
there. Well, no, there was a recent court case that we had in the NCAR, where the judge said that he basically said something like, "Well, the 14th Amendment. If you change the 14th Amendment, that would." And he identified all these different case laws that identified with the 14th Amendment, which basically, gives the federal government ultimately the control. And he said, if you change the 14th Amendment, it upsets. I think he said it upsets the whole apple cart, something like that. Obviously, it would upset the whole apple cart. Because
we think the Civil War upset the whole apple cart.
Yeah. So that's what it's like we go into the court and they're trying to shut us down, but they're saying the exact same things that we're saying. It would upset the whole, and it did.
Yeah, and we take this into court. That's another thing we want everyone to know. We take this into court, and it is meeting resistance. The federal, we're bringing all this stuff in that, we have a right to have our lawful states back there. The state of North Carolina, the body politic is the freemen of North Carolina. It was never changed freely by the consent of the people of North Carolina or South Carolina or Georgia or New York. See, New York was, that's another thing is, most people don't recognize, they think, well, the Reconstruction Act was the 10 southern states. Well, the Reconstruction Act was to nationalize citizenship. They did it by saying, hey, let's do it to the southern states and be mean to them, but it affected New York. New York was changed from the freemen of New York to United States citizens residing there. Ohio was changed. Michigan was changed. They were all nationalized and reconstructed. So this act that was not, the Reconstruction Act was not just for the southern states. It reconstructed the relationship between the states and the federal government from what our founders had.
Eliminating state rights.
Eliminating state rights. And now we are subjugated with benefits.